only females are facing hardships. It's everyone who is facing hardship as and when it comes to one person. As such as I think I am in the academics, basically my career was in ICSI academics. So I didn't face much difficulty as far as career was concerned. The colleagues here, the faculty, means the officers in the ICSI, everybody is very supportive and encouraging and recognizing whatever is being done by you. So at ICSI level, there was no such significance hurdle I did face, though being a female, if we are working, then obviously we have to balance between the two lives, personal and the professional. And we have to, that is a fact in which we have to do a little bit hard work, more hard work. That is the only thing I faced. And happy International Women Day to all. And those, I think there are around 14 participants are here today. I would request all of you to please switch on your videos. We would have it as an interactive session. Today I am seeing here how many this CA Sapna Gupta ji is here, right? I'm just carving out how many females have joined till now. It's not that I'm not recognizing anyone, just to carve out that it is an occasion of the Women Day, in the week celebration of the Women Day. So with me, how many other females are here? Please switch on the video. Shisha Chintapali is here. And Taruna Goyal is here, right? Purnima is here. Okay. So Charu is here, right? Charu ji is here. You all are eminent personalities. Ravitra ji is here. So I am happy that I have got an opportunity by ICSI or IPA to express myself as far as I know about the topic today. Today's topic is interplay of IBC with allied laws. So before starting with it, I would just like to put a query why we are concerned with interplay of IBC with allied laws. What is the reason behind it? Why this is a question that is coming again and again. Okay, Charuji. Anybody?
Actually, for any going concern or any CD, all the laws will be applicable. Na? So when any case is, initiated against a corporate debtor, so all the allied laws we have to follow. That's
Yes.
why.
Yes, that is the absolute thing. That's why we are again and again stuck up at one or the other place that being an IP, I should know about the other laws as far as operation of the CD is concerned. That is what is my utmost duty. I cannot say that I don't know about this law or
Correct.
that law, though it is applicable. It is difficult to take into account all the laws together, but I have tried my best to take some important laws as well as some other laws which are generally there in the various judgments which are appearing again and again. So I'm just sharing the screen. First of all, I would like to share that this is being organized by ICSI IPA for the purpose of workshop that we are going to have as IBC versus allied laws. And just like to confirm whether my PPT is visible.
Yes, it is visible.
It is interplay of IBC with allied laws.
Yes.
Right. Thank you. So whenever we talk about IBC, we always have a glance at what was the objective of the code itself. We all know, I think someone's mic is on. Please switch off your mic. Okay. So this was the code which was enacted basically to consolidate and amend the laws. Why are we using the word consolidate? Because prior to IBC, there were many insolvency laws which have come into pick, whether related to the individual or partnership firm or to those entities which were having corporate sector. So, and they were not yielding the result that was required. That's why the all are put under one umbrella, and simultaneously the other laws are also amended so as to codify only one act, one code for implementation of insolvency laws. So what was the objective? Whether it was an objective to recover, just no. The objective was to reorganize and resolve insolvency of three entities: corporate persons, partnership firms, and individuals. And the focus was time bound, because generally what was happening previous to it was that this was a lengthy process in which assets used to lose the value. And the objective was that there are many economic resources which are being used to create an infrastructure. So rather than to divide it, sell it, let's make an effort that this whole infrastructure can be run by any other person if existing promoters are failing. It is simultaneously promoting the entrepreneurship, availability of credit, and balancing the interest of the stakeholders. This is where we are having many times there are so many judgments coming on it, because it has altered the order of priority of payment of even government dues, which fall under the category of crown debts. So various judgments are coming, and whatever decisions have come earlier, now we are getting some different decisions from the previous views. And IBBI is being established here. So it is at this point we are going to discuss where the standing of the court is changing with respect to the government dues also. When I talk about as an IP, if I am working as an interim resolution professional or as a resolution professional, Section 17, subsection 2, clause E is imposing an obligation on me that I have to comply with the requirement under any law for the time being in force on behalf of the CD. So whether it's with the filing of ITR, GST returns, ROC's compliance, anywhere anything is required under the law, it is I who will be responsible for it, because I am substituting the existing board of directors, which gets suspended once CIRP is admitted. So it is critical for us to understand the interplay between the IBC and the other important enactments. The basic provision that comes again and again in various judgments is Section 238 of the IBC. This section was enacted with a legal intent to give IBC an overriding effect over other laws. What does it mean? It doesn't say that you are going to override each and every law. The emphasis is on the harmonious construction, but wherever there is a conflict, only then the question of which law is going to prevail, and it till few years back, means I would say a year back, the pendulum was always in favor of IBC. IBC was brought in to provide a single framework to deal with bankruptcy and insolvency of persons other than financial institutions. So they were the processes which were there before IBC, they were time consuming, and they were leading to the huge reduction in the value of the assets. The code itself has made some of the changes that includes repeal of the two acts, Presidency Town Insolvency Act and Provincial Insolvency Acts, which were dealing with the insolvency of individuals. It has consolidated around 11 laws, including the Companies Act, Recovery of Debts and Bankruptcy Act, SAFASI Act 2002. It's Section 245 to 255 of IBC, which is providing for amendment in other existing acts because of enactment of IBC. If we look for it, Section 245 is providing for the amendment in Indian Partnership Act, and which says that 41 subclause A is being omitted.
Preeti
now.
ma'am,
Yes,
ma'am, actually our website is visible only. No PPT is visible.
no PPT is visible. Oh,
Yes, ma'am.
oh, you should have told me earlier. Give me just 1 second. Anjali, is it visible now?
Yes, ma'am, now it is visible.
Sorry, extremely sorry. I'm just showing you the glance of it. That was the preamble we discussed. That was the reorganization and insolvency resolution. And this is on this topic. I was saying that the stand of the Supreme Court has changed a little bit with respect to the crown debts. Then the 17(2)(e) of the IBC that we discussed, imposing responsibility on IP acting as IRP or RP to comply with the laws applicable to CD, and section 238 overriding the provisions of the other laws. They are the two acts which are being repealed by the court. And then we were discussing Indian Partnership Act. Indian Partnership Act, Clause A was that a firm is dissolved. Their provision was for the compulsory dissolution of a firm if all the partners or all but one are declared as insolvent. So that provision has been removed here because it is now dealt in Part 3rd of IBC. Section 246, there are some amendments which are made in the taxation statutes, because wherever we look for the tax statutes, they are giving the power, they are giving the authority in the act itself an overriding effect that whatever are the dues, if they are not being paid, they are recoverable as areas of land revenue and they shall be given the priority. The same has been changed by way of amendments being provided in IBC. So section 246 is making a change in Central Excise Act, and thus it is saying that the word surfacey and IBC, along with surfacey, the word IBC has been added. So what it is saying, section 11 has been amended by IBC, whereas first charge is created in favor of revenue, but now it is saying this first charge is subject to surfacey and IBC. So giving an overriding effect to the provisions of IBC itself. Similar are the provisions in the Income Tax Act. Section 178 has been amended, and after the words "for the time being in force," the exception has been provided with respect to the provisions of IBC. So what this section 178 is talking about, this is section 178, it is mandating that whenever a company is undergoing a liquidation, the liquidator shall not, without the leave of the commissioner, part with any of the assets of the company or properties in hand unless and until he is notified by ITO about, unless and until he has been notified by the ITO about the tax liabilities due from the company under liquidation. And then it was a duty, it was an obligation of the liquidator to set aside that amount which was payable as a tax liability to the IT department. Before going to proceed, distribute the assets of the company under liquidation. So earlier the liquidator was required to obtain a NOC from the IT department before proceeding to distribute the assets of the companies under liquidation. But section 178 subclause 6 has stated that the provision of section 178 are not applicable to the companies which are undergoing liquidation under IBC. So the requirement to notify the ITO about the tax liabilities and taking a NOC from the IT department before proceeding to distribute the assets of the company under liquidation is no longer applicable for those companies which are undergoing liquidation in IBC. But still, there was a practice, particularly in case of voluntary liquidation of the companies, that the resolution professionals acting as a liquidator, they were applying to the IT department and taking NOC from there. It was a time-consuming process. That's why a circular was brought on November 15, 2021, and saying that this process of applying and obtaining this NOC from the IT department, it consuming substantial time and thus militating against the express provisions of the code. So the objective of time-bound completion is being defeated here. That's why an IP handling voluntary liquidation process is not required to seek any NOC from the IT department. as part of compliance in the said process. So being a voluntary liquidator or a liquidator, we are no longer required to take NOC from the IT department. It was in Leo edible case. It was held that the same thing was being held as Section 178 is though providing the priority for payment of income tax dues being the statutory dues, but they are subject to the provisions of IBC. And in the event an assessee company is under liquidation under the code, IT department can no longer claim a priority in respect of the clearance of tax dues as provided under Section 178 2 and 3 of the Act. So they are no longer subject to any priority. They have to stand on the footing as is provided by the section 53 of the code itself. So this was about the section 178 amendment. After that was the amendment being made in the Customs Act, and they said for the word surface, now the word surface and IBC is being substituted in section 142 capital A of the Customs Act, which was stating that notwithstanding, that was again an overriding because all the tax revenues which are giving revenues to the government, basically they are all overriding everything. So the opening word is notwithstanding anything to the contrary contained in the Central Act or State Act. Any amount of duty, penalty, interest, or any other sum payable by an assessee or any other person under this Act. So whatsoever it is, whatever is the amount due under the Custom Act, whether be as a duty, penalty, or interest, or anything, it has to be paid in priority and it shall be the first charge. The word here is the first charge on the property. So whatever was the Customs Act, it is standing as, they were standing as a secure creditor, but this was made subject to, along with the Companies Act, RDBFI, SARFASI, this provision is subject to IBC. So the dues of the customs are also falling in the, at the 5th rank in the section 53 of the code itself. RDBFI, there were various provisions being introduced in RDBFI. Basically, the changes were introduced for the power of the DRT and DRAT. That was the scope of the DRT and DRAT was increased to part 3rd, which is governing with the bankruptcy of the individuals and the partnership firms basically. Next was the change in the Finance Act, Section 88, again creating liability under the Act to be the first charge subject to the SARFASI, RDD, BFI. Along with that, that is subject to IBC also. In the SARFASI Act, the name of the SARFASI, in the case of the word figure subject to the provisions of the IBC has been inserted. So we know this is Section 13(9), which has made it subject to SARFASI Act, Section 13(9). We are just going to see what it is having. Is it visible? It's section 13
Yes,
of
it is.
SARFASI. Yeah. Okay. Thank you. So it was saying whenever any security interest is created in favor of secured creditor, it can be enforced without the intervention of the court or tribunal, provided a 60 days notice is being given before taking over the secured assets, and it needs no intervention of any court or tribunal for doing the same. But if the borrower fails to discharge the liability, simultaneously subclause 4 was giving a power to the borrower to take possession of the secured assets, to take over the management of the secured assets. The power was to take the possession, to take over the management of the business of the borrower, or to appoint a manager, or to require at any time any person, even a third party, has acquired a secured asset. It was supposed to give that secured assets back to the secured creditor. But subsection 9 was made subject to the provision of the IBC. They were saying earlier, the provision of the subsection 9 is saying that in case it is a joint consortium loan or it's being financed by more than one secured creditor, if those secured creditors want to take any joint actions like taking over the management or the business or appointing a manager, they could do so only with the 60% approval. But this is now subject to the provisions of the IBC. Once the IBC is into play, they cannot go under SARFAESI for the same. So this was section 39 again made subject to IBC. SICA repeals SIC Industrial Act, though it was prevailing for so long for the SIC industrial companies, but now it was being repealed by SIC Industrial Companies Special Provisions Act. Similar way, there are changes made in Payment and Liability Settlement System, LLP, as well as the Companies Act. The overriding clause, section 238 of IBC, is giving it an overriding clause, and that's why with various other statutes which are already having overriding clauses, conflict arise. Now, reason of the conflict is, first reason is moratorium. What was the principle of moratorium? That in order to ensure that the assets of the corporate debtor are not eroded while the creditors and resolution applicants are negotiating how to resolve the insolvency during CIRP, IBC provides for a calm period. Yes, and section 13 is making it mandatory for the adjudicating authority as soon as whenever a CIRP application is admitted, moratorium is being declared for the purpose of section 14. Now, so what was the case? Whenever an application is made to the adjudicating authority, within 14 days, it either admits or rejects the application. Whenever it admits the applications, the same day, moratorium is being declared. On the CIRP commencement date, moratorium begins. What does this moratorium says? It says it is prohibiting something. What is being prohibited is being given in from A to D clause. The institution of suits. So no suit can be instituted against the corporate debtor during moratorium. Continuation of pending suit. If any suit or proceeding is pending in any court or the tribunal or arbitral panel, it cannot be continued further once CD comes into CIRP. Or if the suit has been instituted, it has been decided, decree is there, but proceedings are not initiated. Once admitted in CIRP commencement date is there, no further proceedings, even for the execution of any decree, order of court of law, tribunal, arbitral tribunal, panel is being permitted, or even by any other authority. So expanding the scope to a bigger level now. Simultaneously, for the purpose of making the assets of the corporate debtor secured, it is being prohibited that the assets of the corporate debtor or its legal right or beneficial interest can neither be transferred nor encumbered, alienated, or disposed of during the period of moratorium. And specific restriction it is giving for the actions that may be taken under SARFAESI, because we know under SARFAESI, secured creditors being banks and financial institutions, once a debt is declared as NPA, then they can go to foreclose, recover, or even enforce a security interest by giving 60 days notice. But any such action cannot be taken against the corporate debtor once it is admitted into CIRP because of moratorium. Similar way, this subclause D is saying that the recovery of property by the owner or lessor which is occupied or in possession of the CD is prohibited. So if the corporate debtor is running its own business on a particular premises which is on lease or rent, then it cannot be asked to vacate it, provided the rent for the moratorium period is paid as and when due, and if not, it becomes a part of IRP cost. The study and similar way essential goods or services to the corporate debtor supply shall neither be terminated nor be suspended or interrupted during moratorium period. And if IRP or so if RP thinks that these things, goods and services are essential to run the corporate debtor as a going concern, the same shall be continued to be supplied to the CD with an undertaking that whatever amount due becomes due for payment for supply for during the moratorium period, it will be paid as and when they become due. Next is, but moratorium is not applicable to some of the transactions, agreements, or arrangements that may be notified by central government in consultation with the financial regulator or any other authority. Similar way, moratorium is not applicable to a surety in a contract of guarantee to a corporate debtor. So, no action can be taken by a creditor to recover it from the corporate debtor, but simultaneously, they can initiate action against the guarantors who are surety to the loan being given to the corporate debtor. Now, till when this moratorium will run? That is the question right now. The moratorium period starts from the date CIRP commences and it ends till CIRP is completed. So CIRP has to be completed either in 180 days. If extension of 90 days is there, then 270 or 330 days. So as and when this period expires, the moratorium also stops. Or it may be any time during CIRP if resolution plan is approved or liquidation order is passed. The same moment moratorium shall cease to have effect from that date itself. The same principle of moratorium is applicable when a company is going into liquidation under IBC also. So section 33 is providing for a situation which is akin to moratorium during liquidation that states that subject to section 52, which is right of a secured creditor to realize the security and recover the debt in case the corporate debtor undergoes liquidation. When a liquidation order has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor. Even any legal proceeding or suit is required to be instituted on behalf of the corporate debtor. Liquidator has to take approval of the adjudicating authority. These provisions shall not apply to legal proceedings. If central government wish to exempt any particular legal proceeding from this provision, it can do so within consultation with the financial sector regulator. So this was basically for the introduction where the conflicts are arising, particularly because of moratorium and section 238 of the code itself. Now we are starting with the interplay, where this interplay is coming into pic. We know that section 230 to 240 of the Companies Act are making provisions for compromise arrangement and amalgamations of the companies. So compromise and arrangements are covered by section 230 and amalgamation and mergers are being covered by section 230 of the Act, 232 of the Companies Act. Compromise and arrangements are basically sort of internal reconstructions which are made between the company and its members or between the company and its creditors. That is how it is proceeding here. And whether the code is permitting this, yes, the code is also permitting this. And for that, I'm straightforward discussing one judgment here, which is given by the Honorable Court, Supreme Court, that in Arun Kumar Jagat Ramka versus Jindal Steel Power Limited. In this case, the issue before the Supreme Court was to decide whether a person ineligible to submit resolution plan under section 29 capital A of the IBC is barred from proposing a scheme under section 230 of the Act. That was the question which was decided here. The corporate debtor moved an application under section 10 of the IBC and which was being admitted on 7th April 2017. Mr. Arun Kumar submitted a resolution plan and he was presented, the same was presented before the COC and put to vote there. In between it was being put to vote, IBC was amended And section 29 capital A was inserted, and it was inserted with retrospective effect. That is 23rd November, when the date the COC meeting was going to be held to consider that particular plan, which was submitted by Mr. Arun Kumar. Now, subsection G of section 29 capital A disqualifies a person from being a resolution applicant if they have been a promoter or in the management or control of a corporate debtor in which either the preferential transaction, undervalued transaction, extortionate credit transaction, or fraudulent transaction has taken place, and in respect of which an order has been made by NCLT under the IBC. So the corporate debtor, yes, the PUFE transaction has been taken place in respect of a corporate debtor, and that the order has been finally made. It is not just the investigation, the order has been finally made with respect to those transactions. So if anybody is a promoter or in management or control of such CD, that person becomes ineligible to submit a resolution plan under section 29 capital A G of the code itself. But simultaneously, a second amendment was made to various provisions of IBC under the IBC code, giving effect to provision G and a provision here. A proviso means exception of this was there, which was saying that this clause shall not apply with respect to a corporate debtor where PUFE has taken place, but they have taken place prior to acquisition of the corporate debtor by the resolution applicant. So if they have taken prior to the acquisition, then such person is eligible to submit a resolution plan. So no further resolution was approved by COC due to the lack of time, and in the absence of that, NCLT passed an order of liquidation after the expiry of 270 days. This order of liquidation was challenged before NECLAT, and NECLAT dismissed that order on this. This was also assailed before the court, honorable court, and simultaneously when the appeal was pending before the NECLAT, Mr. Arun Kumar, he submitted an application under section 230 to 232 of the Act before the NCLT proposing a scheme for the compromise and arrangement between the erstwhile promoters and the creditors. And the same application was allowed. A direction for convening the meeting of the shareholders, secured creditors, unsecured creditors, FCCB holders was being given here. JSPL was an operational creditor preferred an appeal against the order of NCLT before NECLAT. It's against this the order of the NCLT which was sanctioning the scheme of compromise. An operational creditor preferred an appeal before NECLAT, which allowed the appeal, holding that promoters who are ineligible to propose a resolution plan under section 29 capital A are not entitled to file an application for compromise and arrangement even under section 232 of the Act. The basis of this finding is contained in the paragraphs. So this was being held that, okay, if you are not eligible under section 229 capital A, you can neither submit a resolution plan nor you can go ahead for any compromise or arrangement scheme, even during liquidation also. This was the question before the Supreme Court. So if I look for in the meantime, the liquidation process, the Supreme Court, according to the appellant, in the absence of disqualification, NECLAT could not, Mr. Arun Kumar says that Section 230 of the Act is not placing any such sort of restriction on any person for submitting the scheme of compromise and arrangement. Since Section 230 is not putting any embargo, so ineligibility criteria under Section 29A will not be applicable to Section 230 of the Companies Act. So there the clash is coming. So the Regulation 2B, which was dealing of the liquidation regulation, an amendment was inserted by way of a proviso which stated that the party ineligible to propose a resolution plan under the IBC cannot be a party to compromise or arrangement. That was the notification being added by 21st July 2019 in the liquidation process regulations, which was stating that compromise and arrangement scheme should have been completed within 90 days of the order of liquidation. This 90 days period shall not be counted within 1 year mandatory period for completion of the liquidation. Any cost is there, then that has to be incurred by the liquidator, shall be borne by the promoter if the scheme fails, and by the corporate debtor if the scheme is sanctioned, but simultaneously putting an embargo that if a party is ineligible to propose a resolution plan under capital 29 capital A, it cannot be party to a compromise or arrangement. So this was the regulations being inserted, and by the same amending act, section 35(1)(f) was also amended with introduction of a proviso, which was allowing a liquidator to sell the immovable and movable property and actionable claims either by the auction. A restriction was put, neither you can sell, being a liquidator, I cannot sell immovable and immovable property or actionable claim for the corporate debtor in liquidation to any person who is not eligible to be a resolution applicant. So if I look for the application of section 29 capital A, this is applicable to even those who want to submit a scheme of compromise or arrangement during liquidation, as well as they cannot be buyer of any immovable, movable or property or actionable claim of the corporate debtor in liquidation. Report of the ILC also state that section 29 capital A was added to the code by the Amendment Act. Owing to this provision, persons who by their misconduct have contributed to the defaults of the CD or they are otherwise undesirable, they cannot gain or regain control of the corporate debtor by any way. So this provision is basically to protect the creditors by preventing such sort of undesirable person from rewarding themselves at the expense of creditors. So in this interplay of IBC, the thing was, there was an amendment in section 230 of the Companies Act itself with effect from 15th November. The prior to the amendment, an application could be moved before the tribunal by the company creditor or a member of the company. And later on, it was added that even a liquidator of a company which is undergoing winding up can submit the application for compromise and arrangement. Following the amendment, section 231 NVC says that an application which is for a company being wound up may be presented by a liquidator appointed under the code or under the 2013 Act. So when this regulation 2B was, a proviso was added, section 230 was modified, this conflict came to an end. The prohibitions which were placed have now make it clear that one who is ineligible under section 29 capital A, he can neither submit compromise and arrangement scheme, nor he can be a part, he can be a buyer in the sale proceeds of the liquidation of a company under the code itself. So that was basically for the Companies Act itself. Any query with respect to this or anything you want to contribute regarding this, I would say? Any contribution that may be made in this for the compromise and arrangement scheme? Again, we are going to have focus on what is there in conflict with IBC versus PMLA, or how we can implement both together. That is the how they are interplaying with each other. If we look for the disqualification being mentioned in section 29 capital A for a person to be eligible to be a resolution applicant, it is stated that a person shall not be eligible to submit a resolution plan if such person or any other person who is acting jointly or in concert with such person has been convicted for any offense punishable. Means if any person is convicted for an offense and is punishable with imprisonment for 2 years or more under the act which is specified in 12th schedule, or for 7 years or more under any law, he shall not be eligible to submit it unless and until a period of 2 years has been expired after he got released from the imprisonment. Further, this will not be applicable to a connected person. So what my 12th IBC is saying, my 12th schedule of IBC is saying, it is in those, it is in my 12th schedule, this prevention of money laundering is being mentioned. So the one who is convicted under PMLA for 2 years or more cannot be a resolution applicant unless and until he is eligible again after a period of 2 years has expired from his release from the imprisonment. So that is the one place where there is an interplay of PMLA and IBC as far as the resolution applicant are to be checked whether they are eligible or not. Second thing is IBC and PMLA both are special legislation in their own paradigm and deal with different aspects, but the two legislations come to loggerheads when the corporate insolvency resolution process is initiated against the corporate debtor and simultaneously it is charged with the scheduled offenses under PMLA. So we know the objective of the PMLA is to reorganize and resolve the insolvency in a time-bound manner and to maximize the value of the assets. But the object of PMLA clearly states that this is an act to prevent money laundering and to provide. See, it is doing two things. One thing, it is preventing money laundering. Second thing, it is providing for confiscation of property which is derived from or which is involved in money laundering. So here is where the conflict is arising, where they are confiscating a property stating that they are involved in money laundering, and the same is being subject of CIRP also. So this attachment, how this goes on? If we look for the PMLA, first of all, one is indulging in a scheduled offense, earning something which is categorized as crime proceeds. Now, this is one offense. This is not being covered in PMLA. This is a separate offense. What is the offense under PMLA is when he is trying to convert this crime proceeds into untainted, into white, into untainted proceeds, which is known as money laundering, or we can say clean money. So what is the concept here? First, there is a dirty money collection. Then this dirty money is called that money which is earned from illegal acts, illegal sources. Then this money is placed in the banking system, in the financial institutions, in the monetary system, under the different accounts in a different form, so that it gets integrated into the system. And now this money is sought to be circulated abroad, and from abroad that is brought in various forms in India, from where they are as a loan, which will never intended to be paid. But it is now a genuine source. You can spend it, you can show it, yes, this is my genuine source of income. So I can spend it on luxury investments. So this is a game of placement, layering, and integration where my PMLA comes into pick. First of all, this dirty money is collected. This is a scheduled offense which is not covered. PMLA starts from here. In PMLA, there are two separate provisions for attachment and confiscation of the property. Attachment is being done by the ED and then is confirmed by the adjudicating authority. And that is being done whenever it is shown that there is substantial probable cause that the property under attachments are proceeds of crime. But when a trial court, trial proceedings are going before the special court, then in proceedings, proof of guilt of the accused beyond reasonable doubt for the scheduled offense and mens rea must be established. That is the provision of special court here. But first of all, there is a scheduled offense for which a separate proceedings are going on. Simultaneously, there is an offense under PMLA. ED is conducting an investigation. It is going ahead for the provisional attachment of the property and simultaneously filing a complaint to the special court. This provisional attachment of the property, once it is provisionally attached, the final order is given by the adjudicating authority and which confirm the provisional attachment. So this provisional attachment can be for the 30 days by the ED, which is further extended by the adjudicating authority. It is the special court which gives a final order that yes, this was being involved in money laundering directly and indirectly. That's why this shall be confiscated. So there are two parallel proceedings which go in the PMLA. Now, where are we concerned? Because this provision is now, if we look for the PML, it is saying, okay, ED has provisionally attached, adjudicating authority has given a confirmation, you have an appellate tribunal to go in 45 days, and thereafter you can go to High Court in 60 days. So what are the proceeds of crimes? Are proceeds of crimes only which are directly relatable, or it is indirectly also? This proceeds of crime is a bigger in scope, which is stating that the property derived or obtained directly or indirectly by any person because of a criminal activities which is mentioned in scheduled offense. So there is a schedule to the PMLA which is stating that these are the offenses which if committed, it means they are generating proceeds of crime. So it may be direct or indirect. If that property is not there, even the value of such property or some other property that may be in India or outside India, we can take it of the equivalent value, means not only the direct indirect relation, even if that is not traceable, but ED has a conviction, yes, there are proceeds of crime, he can take over, he can attach those properties which are equivalent in value, though they may be located in India or outside India, but the same may be attached here with. Here the conflict starts. When the scope is wider, they are saying the Corp CD is saying that the property of the CD are not acquired from the proceeds of crime. And ED is saying, okay, even whether they are proceeds of crime or not, it will be later established, but they can be attached here under PMLA. So the scheduled offenses are mentioned in three parts, A and B and C. It was held by the, just a minute. In case of Deputy Director ED versus Axis Bank, the Honorable High Court, while deliberating upon the kind of type of properties qualifying as proceeds of crime, they are saying if bribe or illegal gratification is given to a public servant, it is known as direct. This is direct proceeds of crime. But from that proceeds of crime, they are taking some other property. That other property is indirectly proceeds of crime itself. So if a person has committed theft, say of 10 lakh rupees, these 10 lakhs are the direct crime proceeds, but the same has been given to someone at a 10% rate of interest. So additional 2 lakhs are also contributing to the proceeds of crime. Whoever is committing the offense, once it is proved, it may be 3 to 7 year imprisonment. So that is relevant for us while we are looking for whether the person is eligible to be a resolution applicant or not. In case of narcotic drugs, minimum 3 to maximum 10 years along with the fine is there.
Madam,
Now,
can I raise question?
Sir, I have asked, yes, why not?
Madam, my question is regarding the earlier slide that where you were saying that the proceed, if it is established or whatever, till that moment the PMLA, the ED can seize the assets of the CD, any of the assets, because this question I am facing from various PRAs. They keep on asking me, although I tell them that you are required to seek legal advice and all those things, but it is not possible. So, what is your view?
Sir, give me some time till a last judgment that I'm going to discuss with you. Before
Okay,
that,
okay.
I would have said no, the ED cannot attach it if we are following
Okay.
Axis Bank rule and all. But there has been change in it.
Okay.
And that's what is the change here. We are going to discuss those still in substance. We will say that whatever is the property of the corporate debtor, whether it's a part of proceeds of crime or not, if it is passed in resolution plan and that has been approved by NCLT, then the property will go to the resolution applicant. ED cannot attach it. ED has to give it back to the resolution professional. Just last case, if we left out, before that the stance was ED has to return it back. If he has any claim against it, because that was a proceed of crime, he can come as an operational credit.
Okay.
That was the legal case till now. But before that, there is a last case that we will discuss. In that it
Okay.
was some changes have been introduced because of section 32 capital A of the code itself. Right?
Okay. Thank you.
Yeah. So section 5 is giving power to the ED that he can go and attach, and this attachment is a provisional attachment for 180 days. This director is going to, ED is going to it, and he says, okay, any person is possession of the proceeds of crime, and such proceeds of crime may be concealed, transferred, or dealt, which will frustrate the procedures relating to the confiscation. If these are the circumstances, he can go and provisionally attach, but not for a period more than 180 days. Once he is attaching, within 30 days, he has to file an application with the adjudicating authority to give an order further order with respect to the same. Now, once the power of provisional attachment is being exercised and adjudicating authority is being satisfied, yes, if this attachment is not going to take place, then it may frustrate the proceedings of the act itself. The adjudication is saying it. After indicating the sources, they will call it a show cause notice will be issued. Even a third party which is interested in such property and it is not a part of the proceeds of crime, it can come and say that this property belongs to me. So a show cause notice is being issued by the adjudicating authority to indicate what was the source of income, any evidence which can say that this was not the proceed of crime or not relatable to it, and to show cause why this shall not be confiscated. Adjudicating authority given show cause notice. After that, if it decides that the property is involved in money laundering, it will give an order that go ahead, that this property is required for investigation also. So it can be attached for 365 days. The word here is attached. It is not final who is the owner. Till the time the attachment is going on, we don't know whether they are proceeds of crime or they are confiscated or not. This confiscation order is given by the special court. How does this special court says? Yes. This confiscation order is finally given by the special court, and when it is given when it finds that offense of money laundering has been committed and such property was involved in the money laundering or it has been used for the commission of offense, so it shall stand confiscated to the central government. So whether it will go to the central government or not, it depends upon the special court findings. Till the case it is with the ED, it is only a provisional attachment. If a special court finds no, it was not involved in money laundering, it will release it. It shall basically release it. Now, if a property has been confiscated to the central government, but there is someone who claims that please restore this property with a legitimate interest, he can go and claim before the special court that please direct central government to restore this property back to me. I had acted in good faith. I had suffered the loss because the property has gone out of my hand, though I had taken all the reasonable precautions, and that property was not involved in the offense of money laundering. In that case, special court may direct restoration of the property back to the claimant who is proving these three things before the special court. So, even after confiscation, PMLA is giving an opportunity to the bona fide claimants to prove their bona fide and get their property restored back to them. Once the property is vested in the central government, any encumbrance or leasehold interest which has been created on it, that will be declared to be void, and the property shall vest in the central government free from such encumbrances or leasehold. So either that has been mortgaged or anything has been done, here the secured creditors' right will be defeated if PMLA is allowed to be proceeded against the property of the corporate debtor. Moreover, this is a criminal CRPC case-like thing because the provisions of the code of CRPC are applicable, and so far as they are not inconsistent with the provision of the Act. In arrest, search and seizure, attachment, confiscation, the procedure of CRPC will be followed. Section 71 saying that this Act is overriding, the provisions of the Acts are overriding anything inconsistent therewith contained in any other law for the time being. So this PMLA, being a special in nature, was given an overriding power. Even it is saying, say, an appeal has been preferred to the High Court because the appellate tribunal has given a decision, and after that you went to High Court. The person either dies or become insolvent. In that case also, they are giving a right to the legal hire or official assignee in case of a corporate debtor to go and prefer an appeal to the High Court. But IBC, again, the moratorium is there that we have discussed. What are the duties of IRP which are casted under Section 18? Why I am concerned with it? Because I will act either as an IRP or RP, or somebody will, like the sir has said, somebody will come for a legal consultancy with respect to the same. IRP is saying that the IRP shall, Section 18 is stating duties of the IRP, which is saying that IRP shall perform the following duties, namely, taking control and custody of the assets over which corporate debtor has ownership rights, as it may be recorded in the balance sheet, it may be with the information utility or depository of securities or any other registry like CERSAI, etc., which records the ownership of the assets. And it includes even those assets. So being a IRP, I have to take control and custody of even those assets of which the corporate debtor is the owner, but it is not in the possession of the corporate debtor. So if it is with the ED, it is the duty of IRP to take the assets from the possession of the ED and take it back. That is what the code is imposing an obligation on him. Similar way, there is a duty on the IRP to preserve the value of the corporate debtor, which is being stated in Section 20, which says that IRP shall make every endeavor to protect and preserve the value of the property of the corporate debtor. So he has to protect and preserve the value also. And simultaneously, the same duties are being imposed on the resolution professional once either the same IRP becomes resolution professional or someone else comes in place. So the code is saying under Section 23, it is saying to the RP that he shall exercise powers and perform duties as are vested or conferred on the IRP under this chapter. Now the question is to attach or not. IBC versus PMLA. There is a tussle between insolvency proceedings and ED's power. When I talk about whether the first question is Section 14, moratorium. Once the moratorium is there, no further proceedings can be done. PMLA is saying if ED can provisionally attach a property, if it is expected that the same is going to be transferred, concealed, or dealt in a manner which would frustrate the proceedings relating to the confiscation. IBC is saying once a moratorium is there, no further proceedings can be initiated against the corporate debtor. PMLA Section 71 is an overriding provision. Similarly, Section 238 was there in IBC. Supreme Court of India in Solidaire India Limited versus Fair Growth Services Private Limited held that where two special statutes contain non-obstate clause, the later should prevail over it because it is presumed that while the later law was drafted, legislature knew about the non-obstate clause prevailing in the earlier laws. That's why it was held that the section 238 of IBC will override PMLA which was enacted in 2002. The same judgment was being held, followed in the context of the code for the overriding effect over the PMLA in Surendra Kumar Joshi also, and in Raman Ispat Private Limited by NCLT also. NCLT Mumbai Sry Infrastructure Finance Limited means there are so many judgments after that they were holding that yes, the non-obstant clause contained in IB code, which is a later statute, shall prevail over the non-obstant clause contained in section 71 of PMLA. In Sry case, Honorable Justice Manmohan Singh held that this is the status and the line was being given like this. Now, one question was there that was being posed when the government, when the ED is acting, basically it is acting on behalf of the government, is acting under PMLA and is attaching a property or confiscating a property as proceeds of crime, government is not a creditor. Whenever the government is attaching it, it is not standing as a creditor of the offender and not does it wish to be perceived to be sharing the loot with the offender. So while directing the release of attached assets in JSW Steel, NECLET interpreted, okay, though this is not a creditor, but ED shall stand as operational creditor of the corporate debtor who can recover its debt in the order of priority of asset distribution under section 53 of the IBC. If I go to the JSW Steel case, in this we will go a little bit later. Let's go to some other things also, main thing. Now, who will have jurisdiction? In PMLA, it's the adjudicating authority which is having jurisdiction, appellate tribunal is having a jurisdiction, high court is having the jurisdiction in appeal. Then if we talk about the IBC, it's the NECLAT. It is saying when the property of a corporate debtor is attached, NCLT by virtue of section 60, subsection 5 and clause C has exclusive jurisdiction to entertain or dispose of any question of law or fact which is arising out of or in connection with the resolution or liquidation process. So in IBC, the authority to deal with is NCLT. In PMLA, the authority to deal is with the adjudicating authority, to whom we shall approach. Now, there was a landmark decision in case of the proceedings of Messrs. Bhushan Power and Steel in this case, where the ED has attached a portion of the assets of Bhushan Power Steel Limited. JSW Steel was a successful resolution applicant there. Now, what was happened? Appellate tribunal appointed that if assets are seized by the ED as a result of proceeds of the crime, then ED would have a claim over it only in the nature of operational debt. Ministry of Corporate Affairs was also of the view that once a resolution plan is approved by the tribunal, it is binding on all the stakeholders, including government agency. And then they solved out the conflict between the ED and the Ministry of Corporate Affairs, and an ordinance was promulgated where section 31 and section 32 capital A was amended, and a clean slate principle was being introduced that whosoever is coming and taking the corporate debtor, it shall take it as a clean without any defect. That is what there in the 32 capital A they introduced. So in JSW Steel, it was said that resolution plan was submitted by JSW Steel Limited after the approval of the plan when the monitoring committee was going on, seeing the changes in the management, ED attached it. After the PMLA, ED has attached it. One of the question was, after approval of a resolution plan, can ED attach the assets of the corporate debtor on the alleged grounds of money laundering by the erstwhile promoters? See, it is very much clear that whenever there is a crime, it will not be done by a corporate. It will be done by always individuals. So there is no restriction to pursue any proceedings against the promoters or the directors which were involved in that money laundering offense. But sometimes what happens that whatever property they have acquired through the money laundering, they convert it in the name of the corporate debtor. Then how to treat that particular asset? That was the question which came here. So the same held, they said, okay, the criminal proceedings which were initiated against the members of the board of directors and others shall not affect JSW Steel Limited, being the successful resolution applicant. And members of COC can file appropriate applications if criminal proceedings have resulted in because of the criminal proceedings, some money of the corporate debtor has been siphoned off, some assets has been siphoned off, then COC can initiate action against them. But prima facie, they are of the view that if the assets are seized by the ED and finally they hold that assets were purchased out of the proceeds of the crime, in that case, the amount as may be generated out of the assets will come within the meaning of operational debt, which is payable to the ED, for which it may file the application like an operational creditor. That was what the view in JSW Steel case. Later, an amendment in 2020 came into play, which introduced Section 32 capital A. The amendment was a step further to fulfill the objective of the code with an aim to protect the property of the corporate debtor from any criminal proceedings as well. So what it was saying, that was a case, sir, I was referring here, the latest case which has created some more deliberations into the topic. But first see what is there in Section 32 capital A of the code itself. What the Section 32 capital A is saying. See, Section 32 capital A, if we look for it, what it is saying, liability for prior offenses. Clear-cut demarcation it is giving. It is saying notwithstanding anything contrary contained in the code, means this clause, this subsection is overriding the entire rest of the code also, or any other law for the time being in force. The liability of a corporate debtor for an offense which is committed prior to the commencement of CD shall cease if any offense has been committed for which the company is liable once, but the offense was committed prior to CRP, it shall cease and the corporate debtor shall not be prosecuted for an offense. But from which date? From the date the resolution plan has been approved by the adjudicating authority. If the resolution plan, and what was the condition? They were saying once it is approved and the resolution plan has resulted in change in the management or control of the CD to a person who was not a promoter, neither in management or control of the CD or its related party, a person with regard to whom the relevant investigating authority on the basis of material in possession has reason to believe that he had abetted or that it does not have a reason to believe that it had abetted or conspired for the commission of the offense. Means the person, the one who has taken over the corporate debtor is nowhere concerned with the offense which was committed prior to CIRP. Once a prosecution has been instituted, he was discharged from it, and designated partner is covered here because we know in case of CD being the company, it's KMP, and in case of LLP, it's the designated partner who are going to be held for the same. And simultaneously, what they are saying, this is an immunity to the successful resolution applicant. And second part is giving immunity to the property of the corporate debtor, which is taken over by the successful resolution applicant after the plan is being approved by NCLT, because that property was part of the resolution plan being approved. But so we say you cannot take action against that property in relation to an offense which is committed prior to the commencement of CIRP, provided the property is covered under section in a resolution plan, which have resulted in the change in control of the debtor to, see, here they are taking two things into account. Earlier, obviously, immunity to the successful resolution applicant is available only when resolution plan is approved. But the immunity to the property is available in both the situations, whether the resolution plan is approved or the company is going into liquidation. Because there was no resolution plan or nothing was approved, so order of liquidation was being there. So whenever now the liquidator is going to sell the assets, the successful buyer is not going to be punished later on. That is what they are going. They are saying you cannot take action against such property which has been given to the successful resolution applicant, or in case of liquidation by liquidator to the successful buyer or the bidder for the assets, provided in case of a resolution plan this has been approved. It was covered under the resolution plan, and the sale cannot be made to a promoter or in management or control of CD, a person, if the investigating authority was there, he was not abetted, he was clean chit. Whosoever is taking it, whether the resolution applicant or the successful buyer, he was a clean chit person, he was not attached with the offense which was committed prior to CIRP. And what is this action? What kind of action cannot be taken? It is also explained that any action which is against the property for an offense means no attachment, no seizure, no retention, and no confiscation. So everything which is we have discussed in PMLA, whether be the attachment, whether be the seizure or retention, or be the confiscation, no such action can be taken once there is a CIRP or once there is a liquidation. But this prohibition, this immunity starts only at the stage resolution plan is approved or liquidation order is given. Before that, this immunity is not going to be there. That is what is the stand right now with respect to this section also. So this was being held in Rajiv Chakrabarti case, that the restraint of section 32 capital A of the IBBI is not attracted in case only of the attachments, which are considered as proceeds of the crime. And the ED is entrusted with this power by the PMLA, and this judgment has opened a Pandora of boxes. How it is, let's see. What they are saying, a moratorium comes into effect in terms of section 14 of IBC, and that's why section 14 is giving that it would have a power of ED to enforce an attachment. The ED's power is coming from the PMLA. The petition raised a challenge to the orders of attachment which were made by ED in exercise of powers conferred by PMLA. Provisional attachment orders were being, validity was being questioned, and subsequently these, whatever was the attachment was made by ED, it was confirmed by the adjudicating authority also. Now the petition was instituted by the resolution professional of ERA Infra Engineering Limited, which was admitted to insolvency proceeding. It said that this order of attachment is challenged because of the provisions of section 14 of the code itself, contending that once the moratorium had come into effect, the ED stood denuded of the jurisdiction to exercise powers under PMLA. So that was what the stand here. But referring to the Nitin Jain case also, which had preceded the introduction of section 32 capital A, in Manish Kumar Jain also, it says, first of all, whenever a new thing will come in the code, there will be a petition for constitutionally challenging the validity of that particular section itself. But it was held that section 32 capital A is valid, constitutionally valid. And what it is saying, it is terminating the prospects of prosecution or coercive action against the properties when the two events are happening. If either the resolution plan is being approved and the property is part of the resolution plan, or it is a sale of liquidation assets which is being given. So what they are saying is, PMLA's powers are there. What they are saying, section 3 is creating the offense of money laundering. Section 4 is prescribing the punishments. Section 5 and 8 which are giving the power of attachment. Section 5 is giving provisional attachment power to the ED and Section 8 to the adjudicating authority. They are an adoption of the principles of civil forfeiture. And they are an implementation of the intent of the legislature that perpetrates money laundering offenses are not permitted to enjoy the fruits thereof. So the provisions are on non-conviction based asset forfeiture model because they are not convinced that these properties are not the proceeds of crime. That's why they are being attached. The court also went with it. Yes, okay. The government, while proceeding to act under PMLA, cannot be recognized as a creditor because if you go through the definition of the creditor and debt employed in the IBC, you cannot say that action to attach the property under PMLA is just like giving a loan to the company or creating a debt for the company. So when the ED moves to provisionally attach properties which constitute proceeds of crime, it does not do so acting as a creditor. The steps are only to principally attach the properties because they have fear that the same might be disposed of by the one who has committed the offense of money laundering. So, and simultaneously, they want to stop the criminal from enjoying that particular property till the time the proceedings are pending in the with the adjudicating authority. It is further a restraint on the enjoyment of property by the possessor, so they cannot alienate the same. In Axis Bank also, it was being said that PML, whatever the function the government is performing under PMLA, it cannot be viewed as a sovereign like levying the tax or recovering a debt. But it is to take away what has been illegitimately obtained in the course of a person which is indulged in the prescribed criminal activity. So they say there is no such conflict at all. While preserving the right of competitive authority, they say ED is authorized. Section 14 is not applicable for the provisional attachment being made by ED. One thing, contrary to the earlier views, in this case of Rajiv Chakrabarti, they said that ED can provisionally attach the properties till the time the final decision is coming, but this right cannot supersede the right of the secured creditor or other bona fide third party claimant. What it means, it is saying that though in PMLA you attach it, the order is valid and operative, but it would have to ultimately take a back seat in view of section 32 capital A of the code itself. So it is saying PMLA is not concerned with the recovery. Proceedings may be initiated. They cannot by any stretch imagination take an action for enforcement of recovery. This is guided by the illegal legislation, and the same thing is repeated here again, that if section 32 capital A is being attracted, resolution plan is being approved, or the liquidation order is given, then the power of EMLA, the power of the ED under the PMLA or the adjudicating authority will come to a stop. The property has to be given back to the corporate debtor, successful resolution applicant, or in sale of assets to the liquidator, and whatever is left out after making the claims of the creditors and third party, bona fide third parties, whatever is left, that will go back to the PMLA. And ED again would stand as an operational creditor, but only after the resolution plan, only if there is a successful resolution plan or if there is a liquidation. Before that, PMLA's power vested in the ED are not going to be questioned. That was what they are. Sir, I think now it is clear the change in the view.
Yeah, that means during the CIRP, the attachment is
Yes.
possible.
Yes.
So this is very important actually.
Yes, this Rajiv Chakrabarti case has changed the earlier stance.
So is there any appeal also in this matter?
No, sir. This is something that is being changed right now.
No, but this is High Court judgment, correct?
Yes.
So is there any appeal against this?
Sir, till now, no such thing is there.
Okay.
Rest we see, obviously there would definitely be appeal. We can never deny this, but
Hmm.
this case has highlighted the importance of introducing Section 32 capital A, which is giving immunity to the successful resolution applicant in person or buyer of the liquidation estate in case of liquidation, as well as to the property of the corporate debtor, either for passing on to the successful resolution applicant or to the successful buyer also in liquidation. Right?
Right.
This is where the question, this is again start. The process is again started. And the question, the earlier section 32 capital A was not there, but when section 32 capital A has been introduced, they are saying section 14 is not applicable. The moratorium is not applicable to the attachments being done by the ED under PMLA.
What is the date of this journal?
So this I have to check out. Basically, this is reserved on this and it was pronounced on 11th November 22, basically. Sir, you are mute.
I am saying this is quite old, almost 1 year
Yes.
back.
Yes.
Okay, then we'll have to see what is the current status. Maybe some stay is there in Supreme Court or not, whether it has been appealed or not, that has to be checked.
It has to be checked, but till now there is nothing available in further
Okay.
course of action. Matlab till date of today, whatever was my search, there is nothing that showed that something else has been there in it.
Thank you.
So this was basically the case. I can give the copy of the case itself also. Just a minute, I am just closing some of the additional windows.
Okay.
Is PPT visible? No.
Yes, it is.
It's with respect to the Competition Act, right? Any idea, means anything that any provision of IBC which is connecting us to the Competition Act?
Yeah, there is a provision in the IBC which says that the resolution plans, if some approval is required from the CCI, then it has to be arranged.
Yes, absolutely correct. So after PMLA, I am taking a lighter note of the law. That is section 31, section 4 of the IBC, which is requiring the approval of the CCI prior to the approval of resolution plan by COC. Now the question here is whether the requirement of approval by CCI, and that's true prior to approval of resolution by COC, is mandatory or directory under the provision of section 31, subsection 4 of the IBC. So what the section 31 and subsection 4 is saying, the resolution applicant shall, pursuant to the resolution plan. See, what is the difference between the approval of CCI and approval that may be required under the other law is that this section 31 is giving a time period of 1 year from the date of approval of the resolution plan by the adjudicating authority, or such period whichever is provided in law, whichever is later, to take the approval that may be necessary under other sections, under other laws. But as far as CCI is concerned and provisions of the Competition Act for Section 5 is concerned, if the resolution plan is providing for any combination, for any merger, for any amalgamation, then such combination is coming within the purview of Section 5 of the Competition Act. then the resolution applicant shall obtain. Who will obtain the approval? It's the resolution applicant. And he will obtain the approval of CCI under that act prior to that being approved by the committee of creditors. Now, what the sense says is, okay, first of all, the proposal will be made in the COC, and then if it seems that, okay, the approval is going to be made by COC with respect to his resolution, then the means what is deemed here is then resolution applicant will file an application with CCI and take the approval for the proposed resolution plan. The question arises whether this approval is, but can we think of that it will be within the time-bound process as is envisaged in IBC? Please let me know, can we think of this is a time-bound process of 180, 270 or 330 days or some period that may be extended? Will it be, some means our infrastructure is so loaded that it is not possible to take the resolution plan approval within the time frame, generally, practically, basically, I would say. So the question is, this approval prior to the approval of resolution plan by COC, can it be obtained prior or can it be obtained after COC approval but before the implementation of the plan? This question has been addressed by the NECLAT in its landmark judgment in Soneco Marketing Private Limited versus Greece, Sriram, Juneja and others, whereas it can be held that approval, this prior approval is directory and not mandatory. Because the main objective is to maximize the value of the assets, and that's true in a time-bound process. And empowering the IBC to decide, basically COC is empowered to decide the fate of the insolvent entity. While the main objective of the Competition Act is to prevent the practices which would have an appreciable adverse effect on competition in India and to protect the interest of consumers and ensure freedom of trade. For that, it is regulating the combinations and those that may affect an cause an adverse appreciable effect on the competition. When I look for the interval, in Soneco Marketing case, when it was dealing with an appeal which was passed against an order of the NCLT, which had rejected a resolution plan. Soneco Marketing has submitted a resolution plan, but the same was rejected by NCLT on the ground that it did not have prior approval from CCI as is required under section 31(4) proviso of IBC. Soneco had submitted its resolution plan for revival of corporate debtors Sri Metallics Limited, which was undergoing CIRP, and the plan was approved with 100% voting. NCLT rejected the same because this did not have prior approval from CCI, and one section 29 capital A disqualification was there. But we are concerned right now with the prior approval. What was being held? Requirement of approval by CCI prior to approval of COC is directory and not mandatory because the timeline in the CIRP completion is stringent. We cannot extend it beyond 330 days, while the Competition Act is itself giving a time period of 210 days for obtaining approval from CCI. So if a prior approval is made, you are going to make it mandatory, then another 210 days you take into account, which is not the focus of IBC. So approval is mandatory, but it is mandatory before implementation of resolution plan and the combination becoming effective. So NECLAT relied that prior approval from CCI is directory and not mandatory in this case. This is a significant one, and the same is again reaffirming that prior approval is directory and not mandatory, but before implementing the plan, it has to be taken. That is what is being held. Any query with respect to this?
No, madam. Thank you. Thank you very much.
There is one more thing in that there's one more simplest one. I am just taking the simplest one, the easy one right now. But generally, we don't look at it unless and until we are dealing with the corporate data in that particular, covering under that particular act. So there is that IBC and the T Act. This was a judgment being made in 2019 by Supreme Court in Duncan's Industries Limited. And it was held that provision of IBC are overriding the provisions of the T Act 1963 that was giving requiring the consent of central government to initiate winding up proceedings or for appointment of receiver against a company or which is owning tea estate in case the management of the tea estate owned by such company has been overtaken by the central government. So if any corporate debtor is there, the management of which has been overtaken by the central government and one that wants to go ahead with the CIRP or any creditor or wants to go ahead for CIRP, it was stated that do it need approval of central government before proceeding with that. It was held by the apex court that insolvency resolution process as such cannot be equated with the winding up proceedings. So we have to take it in mind whether it's with the Companies Act because winding up is nowhere used in the code itself. Winding up is there in the Companies Act. And the court has held that CIRP cannot be equated with the winding up. If we are making it a requirement to obtain central government before proceeding with the CIRP, or we will have to take the approval, the objective of IBC to complete in CIRP would even frustrate it. We won't be able to maximize the value of the assets. That is the objective of the IBC. So it held that IBC provisions would have an overriding effect over the provisions of the TA, and any other interpretation would frustrate the object and purpose of the IBC. So that was the T Act, which is also being overridden. The chaos is only in the PMLA, which is has changed the stance now. Just a minute. Can an application for CIRP be rejected on the ground that the documents or the agreements of the financial debt or the operational debt are insufficiently stamped? Please tell, can NCLT says the documents are not properly stamped so they cannot be admitted into evidence under the Indian
No.
Evidence Act? No.
No.
Right. It cannot be a ground. Though the Stamp Act make it necessary to get the stamp if we want to enforce that particular contract, but IBC has overridden this. Why this IBC? IBC has laid down the provision and procedure regarding the initiation of insolvency procedure. But the plea of insufficient stamping by the provision of the Stamp Act has been used as a defense number of times that you cannot admit that as an evidence. Various applications were made, but it was being held that non-stamping of documents is not rendering CIRP application non-maintainable. If there are other materials on the records which are an evidence of yes, default exists. Because what is the crux of IBC is default. Brijeshi, I think you are... Brijeshi, please mute yourself. But non-stamping provision not maintainable means documents insufficiency of the stamping instruments. That was not a obstacle as far as Section 7 application was concerned. Till now, the judgment was with respect to the Section 7 application. But then the similar principle is applied with respect to an operational creditor being Standard Chartered Bank Singapore and which has filed an application for CIRP of RCI Industries and Limited. This was being filed.
Madam, I am continuing RP in this case only.
Oh my God, sir. Then how is the status now? You have gone through it.
Yes. It is in the process.
It is in the process.
Second time Form G has been issued and we are about to receive resolution plans.
ओके ओके, ग्रेट ग्रेट सर। तो फिर मुझसे अच्छा तो आप ही बता दो इसको।
नहीं नहीं, मैंने नो बोल दिया ना पहले, इसीलिए।
You can give a better insight into this. Those who are associated with it, and lucky enough that you are here with the case going on right now.
No, actually, the crux, what you have explained, that it was only, the challenge was only limited to the ground of stamping of the documents.
Yes,
So this has been rejected at the NCLAT level. And now they have filed appeal before the Supreme Court, and no stay is there.
no stay is there till now.
Yeah. So it has
And
been,
the CIRP is going on, right?
yes, yes.
Mhm.
CIRP.
So while rejecting an application, this was being held by NECLAT. Basically, this was a factor receivable agreement that was being assigned to, this was an operational debt which was assigned to Standard Chartered Bank Singapore with respect to the corporate debtor, that is RCI Industries. And the assignment deed was duly acknowledged. It was signed also. But the thing was, it was not sufficiently stamped. And the objection was RPA for the assignment of debt having been executed in Singapore, so it need not be stamped under the provision of the Stamp Act. If I go to this, section 9 of the IBC is saying, first of all, there is a default. Second, there is no pre-existing dispute. If these two are satisfied, then you cannot say that documents are not sufficiently stamped. And in this case, because the notice of assignment of the debt, because operational debt includes assignment of the operational debt also. So the same, just saying that the same has not been sufficiently stamped. It cannot be held. The reliance that was placed in section 7 applications of IBC, the same shall be taken in case of operational creditors also. NCLT agreed with the submission that is made by the Singapore Bank, and they said yes, the same shall application under section 9 of the IBC is maintainable. This was, just a minute, there's some points that we wish to discuss or just focus on. See, we also say in the Stamp Act, when we go through the provisions of the Stamp Act, the person who is looking for the insufficiency of the stamp, there are provisions for getting them impounded also. But what was held by in the, there were various judgments that were discussed also in the concentric investment case. It was held that facility arrangements were not duly stamped, but there were other materials on record. So one thing to be taken into account is, apart for the agreement, there are other evidence. The instrument that is being challenged is insufficiently stamped, but there are other materials on records which are giving you a reliance, which are giving a reliance to the tribunal or the appellate tribunal, that and come to the conclusion, yes, default has been committed by the corporate debtor in paying the debt. The same thing was there in the Ashik Poonam Prabhat case also. Even it is considered that term loan is insufficiently stamped and can't be accepted in evidence. The debt and default are proved beyond doubt. That's why application is complete. And in the Lalanggar also, they say assignment cannot be challenged because the party had a knowledge of the assignment deed. So even if the documents are not stamped sufficiently under the Indian Stamp Act, such non-stamping shall not render the application under Section 9 as non-maintainable. Again, highlighting the point that there are other material on record which can be relied upon to come to the conclusion that corporate debtor has committed default in payment of debt. Therefore, the present application under Section 9 of IBC is maintainable. So simply filing just an agreement which is insufficiently stamped may be questioned relevantly. We can succeed only if there are other material on record to prove, yes, there was a default in payment of debt beyond the threshold limit. Right? So this was regarding the Singapore case. Just a minute. So I think we shall have a break of 10 or 15 minutes. Will it be okay, Anjali? 10 minutes?
Ma'am, sure.
10 minutes, within 10 to 15 minutes, please reassemble so that we can continue ahead also. Okay? Till now, in between, if anyone is having any query, you can ask the same. Shall we resume? Anjali? Anjali, shall I start now?
Yes, ma'am. We can start.
We can start. Okay.
Let's start.
Okay. Is this PPT of RERA visible to you?
Yes, ma'am, it is visible.
Okay. So RERA is not something we are not aware of because there were many changes being introduced for, as far as they are dealing with the home buyers. And home buyers is considered a special class as they are basically investing their hard-earned money for the purpose of getting a house to live for. Or it may be some other projects, even commercial projects are being covered under RERA. Please, someone's mic is on. Okay. And RERA came into effect in 2016 itself when IBC was enacted, though RERA came into effect on 1st May 2016 and IBC provisions basically were enacted or they came into force with effect from 1st December 2016. Almost 6 months gap was there. We know the objective of the code, but what is the objective of RERA? The objective of RERA was to establish the RERA authority so as to regulate and promote real estate sector and to ensure sale of plot, apartment or building or sale of real estate project in efficient and transparent manner and to protect the interest of consumers. In the real estate sector, establishing and dedicating mechanisms and the appellate tribunals are there, the other matters are connected there. So the basic purpose here, what we are going to deal is to protect the interest of consumers data, and that's to specifically the home buyers as far as IBC is concerned. Now, there are some definitions which IBC is referring to the RERA. That is the definition of allotee, which means in a real estate project, the person to whom a plot, apartment or building has been allotted or sold, whether it's freehold or leasehold or otherwise transferred by the promoter. And the underlined word is otherwise. So if the promoters are transferring it otherwise, they are also the allottees, and includes the person who subsequently acquires the said allotment through the sale, transfer or otherwise. But they do not include those to whom such plot, apartment or building is given on rent. When I talk about real estate project, it means the development of a building or a building consisting of apartment or converting an existing building into the apartments or developing a land into the plots or apartments for the purpose of selling all or some of the said apartments also. And it includes the common area, development work, improvement and structures thereon with the easement rights. Prior registration of every RERA project is mandatory. Even before giving any advertisements, marketing, booking, selling, it is necessary that the project shall be registered with the RERA authority. However, in some cases where it is renovation or a small area is involved, up to 500 square feet, this prior registration is not necessary. Some compulsory requirement on the part of the developer is he shall have a legal title free from all encumbrances, at least 70% amount to be deposited in a separate account and proportionately to be drawn as much as is required for the project. Because we all know before RERA came into pick, what was the status of the home buyers or the persons who were giving their hard-earned money for procuring some land, some flat or a commercial build, office and all in our projects being developed by these developers. Basically, DLF was criticized a lot, and it came into grip that they are defrauding the persons who are giving their money for the development of a particular apartment or a building. Now the restriction is whatever the amount is there, it shall be kept in separate account and shall be proportionately drawn as a depending upon the percentage of completion of the project only after certificate from engineer, architect, and CA in practice. And simultaneously, audit of the accounts is compulsory here. Now, there is a duty of the promoter. What is the duty? That he shall execute a registered conveyance deed in favor of the allotee and hand over the physical possession and the title documents pertaining to there. And if there is no local law, conveyance deed in favor of allottee or association of the allottees shall be carried out by the promoters within 3 months from the date the occupancy certificate is being issued. So it is basically the compulsory duty that is being attached to the promoter. And apart from that, there is something very important which is being inserted here is if the promoter fails to complete or is unable to give possession of the apartment, plot or building in accordance with the, just a minute, in accordance with the terms of the agreement for sale, or because of discontinuance of the business as a developer because his registration has been suspended or some other, or it has been revoked, he shall be on demand of the allottees in case the allottees wish to withdraw from the project. Along with the other remedies available, he shall return the amount which is received by him in respect of that apartment, plot, building, with the interest that may be prescribed, including the compensation that may be there in the manner provided under this act. So what is they are saying, along with the interest and compensation, the amount shall be returned back to it. But if the allottee does not intend to withdraw, he shall be paid by the promoter interest for every month for delay till the possession is being handed over. So this is the liability being attached with the promoter, and simultaneously he shall compensate the allottee if any loss is caused because his title was defective. And such case, you can, or being an allottee, I can always raise the plea for compensation for defect in title without looking for the limitation period. That is the beauty of this particular RERA, that is given, they are strengthening the hands of the allottees basically. In case there is any grievance, we can always approach the adjudicating authority in this case. And the authority shall be guided by the principles of natural justice. What RERA, like the other are taxation statutes, they are giving the part that if promoter or allottee or real estate agent fails to pay interest, penalty or compensation, it shall be recoverable as an arrears of land revenue. So that they are giving the power to recover it as an arrears of land revenue. And if we want to go to real estate appellate tribunal, at least 30% penalty or higher shall be deposited. Now, if there is any dispute and appeal which is made to the appellate tribunal, it shall be settled within 60 days or as soon as possible. And then it appeal to the High Court within a period of 60 days from the date the appellate tribunal communicate the decision, appeal can be made to the High Court. In case a project is not registered, up to 10% of the estimated cost shall be given as a, may be levied as a penalty, and along with that, and if further non-registration is done, then imprisonment provision is also there. But now comes section 79, which says that only RERA adjudicating authority, appellate tribunal have an authority under the act to determine any issue. No other civil court shall grant any shall have any jurisdiction to entertain any such suit or proceeding. And further, no injunction shall be granted by any court or authority in respect of the powers which are conferred on RERA authority under this act. simultaneously, any court will not take cognizance of an offense unless and until the suit is being filed by the authority or the officer of authority. Section 88, another relevant, which is saying this is different from the other. What it is saying? RERA's application are in addition and not in derogation. So if one is having grievances, it can approach RERA authorities definitely for relief under RERA, but simultaneously it can take the remedies under other laws also, like in the Consumer Protection Act. Yes, sir. Yes, Raji. Definitely, I will share PPTs. Now the act shall have overriding effect. Again, see the both 2016 acts, RERA as well as IBC. And RERA is also saying sometime before it was enacted, but it is also giving an overriding provision that if there is something inconsistent anywhere else in the law, then provision of RERA shall have effect. Preamble of the code we know. Commencement and this we know about. Now clash of IBC and RERA. IBC wins. That was the Pioneer Urban Land and Infrastructure Limited case in which it was held that provisions of RERA law should give way to the provisions of code when both of them clash. What was the issue at that time? The constitutional amendments were made in the IBC wherever the LOT and real estate projects, they were included in the definition of financial creditor. How is it? The conflict between RERA and IBC often arises in cases where a real estate developer faces financial distress. While RERA focuses on protecting the rights of home buyers and ensuring the completion of the projects, the IBC is more concerned with the resolution of financial distress and the maximization of the value of assets. Balancing these two objectives obviously can be challenging. But before the Ordinance 2018, Supreme Court decisions or the earlier decisions were already in favor of home buyers, particularly the home buyers, because Nikhil Mehta and Sons, NICLAT held that amount raised by developers under the assured return schemes had commercial effect of borrowing and accordingly can be called as financial creditor to trigger the CIRP. In the matter of Chitra Sharma also, Supreme Court allowed the home buyers to appoint a representative who will participate in COC meetings so that interest of home buyers pertaining to CIRP of JPS could be protected. In the matter of Amrapali also, Supreme Court again gave permission for representation of home buyers in the meeting of COC. So they were the judgments being made by the Supreme Court, and in Supreme Court decision, NICLAT also went ahead with the same. Then came, because these developments were there, that's why there were amendments in the IBC in 2018. Even the ILC committee stated that non-completion of real estate projects is common and the amount which is raised is also very significant, raised against time value of money, thereby making IBC proper forum to resolve the dispute, as the code provides for the definition of financial debt and lotteries would perfectly fall under the definition. See, what was the intent behind it? If I am in a lottery and I have made some payments, it's not that the developer will use that payment only to develop my apartment. He is going to use it in development of the project as a whole. That's why that particular contribution by each LOT is considered as having commercial effect of borrowing. So what it is saying, that the amendment, what was the changes being made? First was the change in section 5 subsection 8, that any amount raised from a LOT under a real estate project shall be deemed to be an amount having the commercial effect of borrowing. And attached with it, LOTs and real estate project definition, look for the RERA for the same that we have seen. LOTs are those which are having, which have either bought it or to them they are being transferred. The project is there. The amendment had further allowed the home buyers being the financial creditors. Now, the Supreme Court were allowing, they said, because the home buyers are the financial creditors, so they should be allowed to have representation in COC through an authorized representative and have voting right. And simultaneously, With the above ordinance, an amendment was carried out in the CIRP regulations, introducing a separate category for home buyers. Home buyers were categorized as creditors in a class, and Form FA was being recognized for submission of their claims. Earlier, before that, there was no Form FA. So when I look for the definition of the financial debt is always a debt along with interest, which is dispersed against the consideration for the time value of money, and it includes the amount which is here the home buyer's money is being considered as the amount which is having the effect of commercial borrowing, which is raised under any transaction, including any forward sale or purchase agreement, because in the real estate there are generally the agreement to sell, and then they have the commercial effect of borrowing. So any amount raised from an allotee will be commercial effect, and the definition to be borrowed from RERA itself. When in Nikhil Mehra case, it was held that home buyers are considered as financial creditors. That was case specific, fact specific, because in the scheme, in the agreement to sell, they were there was assured return scheme, where the seller had to pay the assured return till the buyer gets the actual possession of the property. That's why the scheme was the amount given by the home buyers was treated as a loan and the financial debt because of this assured return clause. And at that time, there was a Form F, which was issued by IBBI for creditors other than financial creditors or operational creditors. So Form F was indicating, there was no Form FA at that time. Form F was indicating that home buyer is neither financial creditor nor operational creditor, so they have to file Form F. In Chitra Sharma case also, the home buyers could file in Form F, but they would not be treated at par with the financial and the operational creditors. So again, the same sentiments of the home buyers was discussed in the Chitra Sharma case also, that they want a house, they are spending their hard-earned money, they are giving the hard-earned money with the trust in the hands of the developer. And the IBC, when originally enacted, it didn't give adequate recognition to the interest of home buyers in the real estate project. Initially, it did not protect it, but it's the Ordinance 2018 where the protection came into pick after the judgments that are being held in case of Nikhil Mehra case. As a result of amendment of financial debt, they were considered as commercial effects and the financial creditor. Also, they were given a right to represent in the COC. Regulation 16A contains provisions for the selection of an authorized representative to represent the financial creditors in the class. If I look for the financial creditor category, first of all, a creditor has to submit a claim with the proof on or before the last date mentioned in the public announcement. So they have to submit their proof within 90 days or before the issue of RFRP. Regulation 16A was saying that authorized representative has to be selected. And who will be the authorized representative? He will be an insolvency professional who will be the choice of the highest number of financial creditors in the class in Form FA, which is received before the last date mentioned in the public announcement. So if any home buyer is filing a claim, but the claim is being filed after the public date mentioned in the public announcement date, his vote will not be counted for selection of their authorized representative. Then this authorized representative name will be sent to the NCLT, which will finalize the name of that. What was more important here in this regulation is they said that the voting share of the creditors in the class shall be in proportion to the financial debt, which will include the interest rate of 8% per annum. When we were discussing RERA, if the promoter was not able to give the possession in time and they want to withdraw or continue, interest at the prescribed rate was mentioned. But in case of IBC, rate percentage is being mentioned is 8% will be mentioned in their debt, and that will be added to it, their total debt. Now, one more change was voting of the authorized representative. It is different from the other financial creditors. When we look for the other financial creditors who are not the related parties, their voting is proportionate to the debt in their total financial debt. And we need a 66% voting for approval of the any resolution plan. But when I talk about the creditors in a class, say home buyers, whatever be the decision taken by the majority, that will be counted as a decision of the entire class. So, because taking the 66 or 75% approval of the so scattered home buyers was not considered to be feasible, they said, okay, even 50%, if 50% is approving the resolution plan, so then whatever is the proportionate weight, voting of all the whole class in the total financial debt, it will be counted as yes. Otherwise, it will be counted as no. Similarly will be the contribution, but if there is a vote to be cast in respect of withdrawal application, then it shall be the individual voting which will be countable. This was basically the authorized representative right which is given to them. One more question was there in Chitra Sharma case. JP in Chitra Sharma case, there was some amount that was being deposited separately with the NCLT, and later on it was being claimed that those home buyers who are not willing to continue with this further CIRP, those who want to withdraw from the project, they don't want to get the flat, they want their money returned back. They shall be given the proportional refund out of this 750 crore. That was this. Then it was held that during the pendency of CIRP, it would be a matter of law be impossible for the court to direct a preferential payment being made to any particular class of financial creditors, whether they are secured or unsecured. Directing disbursement of the amount of 750 crores to the home buyers who are seeking refund will be an injustice, manifestly improper, and cause injustice to the secured creditors, since it would amount to a preferential disbursement to a particular class of creditors. So it was held that it is not possible that those who want to withdraw from it, they would be given the money, and those who want to continue, for them, we will decide the fate during CIRP. No, we cannot create a class within a class. That is what was the justice behind it. That in Pioneer Urban Land and Infrastructure case, considering the report of ILC, the constitutional validity of the amendment of 2018 in Section 58F was being held. Supreme Court held that legislative judgment in economic choice must be given a certain degree of deference by the courts, and the amendment shall be read down to lay down the reasons for the current amendments as stated by the ILC also. So it is important to clarify that home buyers shall be treated as financial creditors, and they shall have a rightful place in COC when it comes to making important decisions as to the future of the company, which is the execution of real estate projects. Because RERA is something different. There, home buyers want the project to be executed. They don't want the sale of those particular plots or the lands, and then if they get somehow scatter of money, they are not interested in it. They want that project to be constructed. That is the interest behind it. And what was the benefit of creating the class was, see, an individual buyer, they are voting, they are so scattered, they may vote, they may not vote, whatever it is. But as a strength, if authorized representative is getting a 50% voting, in the entire their total financial debt will be counted for that particular voting. That is the effect of creating the class and giving them a unity. When we talk about the IBC versus RERA, in Pioneer Urban, it was held that Section 88 was discussed, which is saying RERA is an addition and not in derogation, though Section 89 is giving an overriding effect. But again, Section 238 was enacted later on, and there is no such provision similar to section 88 of RERA in anywhere else. That's why they are saying RERA is allowing the other remedies also. Further, the same was being held that because the one which is later will obviously supersede the previous one. So this was an amendment when the who can file the application. There was an amendment that was given in section 7 for the financial creditors who are allottees under section real estate project. The application shall be made jointly, but at least 100 of such allottees, but they shall be under the same real project, or 10% of such allottees, a total number of such allottees, whichever is less. So what they are saying, the developer, the corporate debtor may be in the maybe in execution of different RERA projects, but if you want to make an application as a financial creditor being home buyer, again the concept of minority representation is there, which is already there in the Companies Act for 10%. Similar was being introduced in IBC that at least 100 should come, or 10% of the total number of allottee, but under the same real estate project. So this was a threshold being imposed in it. Again, there will be a constitutionally valid challenge will be made, but this was said no, this validity, this is valid. And in section 35 also they say, and subject to the direction of adjudicating authority, the liquidator shall have the powers that subject to section 52, he shall not sell movable and immovable property. He shall sell the movable and immovable property only by auction and not to a person who is not legible, and liquidation shall be completed within 1 year. If by chance the entire corporate debtor goes in liquidation, then where will home buyers being the financial creditors stand? Can anybody tell? What was the benefit of including the home buyers in the status of financial creditor? Where would they fall? Can you tell? The position of home buyers. If we go through this process, the position of the home buyers, if the sale deed has been executed, then they will stand at here, relinquishing their security. Then second one, and if they have not relinquished the security, then the fifth rank, pari passu with the government. But if they are under agreement to sell, they will fall in the fourth category, that is financial debts owed to unsecured creditors, and very less is expected to them after the distribution of the liquidation estate here. So there has been now a provision of reverse CIRP that is being introduced, particularly with respect to real estate project. And this was being identified in Flat Buyers Association, Winter Hill 77 Gurgaon versus Rumang Realtech Private Limited through IRP and others, where the one project is specifically taken out in CIRP process and assets and liabilities of the project are kept separately. You might be aware of that in RERA, in case of real estate sector, now the initiative is to enable them to make a project-wise CIRP. Means project-wise, they shall be permitted if they are interested, because home buyers want to construct it, and that was being highlighted in the Umang Realtech Private Limited case also, where after the CIRP being admitted, one of the promoters, Uppal Housing Private Limited, agreed to remain outside the CIRP, but he intended to play role of a lender. He wants to infuse some funds to ensure that CIRP reaches success and the allottee take possession of their flats and apartments during CIRP without any third party intervention. So he doesn't want some other one to take over the project. He wants to give the funds himself, but simultaneously The Flat Buyers Association also accepted infusing the remaining funds. They were willing to give the remaining funds that were due from them. One of the promoter, Uppal Housing Finance, agreed to finance it, but from the outside. It's only the IP who will look for it. He will finance it. That is the one. And one more, JM Financial Credit Solution also contributed 30%, that they will get 30% of the amount paid by the allotee at the time of the flat or the apartment, because in terms of the agreement, whenever it was being registered, and allotee will pay the remaining. So the loan of JM Financial Credit Solution will be paid from it. If we go through this Flat Buyers Association, one of the promoter came here for the Winter Hill. So it was being held that Uppal Housing Finance is directed to cooperate with the IRP, disperse the amount from the amount already dispersed from outsider as a lender and not as a promoter. So he will act as a lender, not as a promoter, to ensure that the project is completed with the given time frame. The amount dispersed by the Uppal Housing Private Limited and the amount that will be generated from the dues of the allottees during CIRP will be deposited in a separate corporate debtor account to keep the company as a going concern. Then the amount can be utilized only by issuance of check, which will be signed by the authorized person. Means company is running right now. It will be signed by the authorized person with the countersign of IRP, but it will run under the supervision of IRP. Bank in which the corporate debtor has an account, the amount shall be deposited only the amount will be used for completion of Winter Hill 77 Gurgaon project, and bank will allow the checks for encashment only with the counter signature of IRP. So it was a separate protection reservation being given to a particular project, though the corporate debtor was running the other projects also. So it was a project specific CIRP that was being allowed without change in without someone successfully taking over the company, because it's the flat buyers who were interested in completion of the project and getting this flats handed over to them. Now the question was whether the moratorium is applicable only to the Winter Hill project or to the entire corporate debtor, and the moratorium is applicable to the other projects also. That was the question being raised further. It was held that in this case, appellate tribunal noticed that even the Honorable Supreme Court of India in Naren Singh versus Umang Realtech Private Limited dismissed the appeal which was filed challenging the order, holding that there is no ground. So when reverse CIRP process was being recognized by the NCLT and Flat Buyers Associations Limited by the appellate tribunal, then the same was upheld by the Supreme Court also. And it becomes that this was being given as a clarification that the order is confined only to the Winter Hill 77 and not to the other projects of the CD. And that's why the moratorium is deemed to be applicable only to Winter Hill 77 and not to the other projects of CD. So it said that it was the first time the concept of reverse CIRP was introduced in Umang Realtech Private Limited. That's why this was the particular specific case where the moratorium was being applied and CIRP was carried out, and the flat buyers themselves come ahead to let it be completed, and one of the promoter also supported in it. So summary of this, there was an agreement between the promoters and allottees to let the promoter act as a financial lender of the project, promoter to remain outside CRP, but to ensure the allottees get the possession without any other third-party intervention. Time frame has to be given by the promoter within which it will be completed. Promoter also provide details of the amount which is dues and what is the default committed. It will be deposited in a separate account. Check will be issued only after being countersigned by IRP. Separate account for the particular project only, and encashment only with the countersign of IRP. Financial institutions and banks to be paid simultaneously, and allottees will also pay their dues. The resolution cost, including the IRP fee, will be borne by the promoter. This is what we highlighted, that if I am the IRP or RP of such one, then I will get my fee from the promoters. And if the unsold flats and apartments are left out after the certification of completion, they will be given to the promoters only after getting a clean sheet from the IRP and the adjudicating authority. Then came the Rajesh Goyal versus Babita and others case. LOTs agreed that promoters shall act outside as the financial creditor and they will invest the amount, but not from the corporate debtor, but from their other sources, because they want to keep the corporate debtor as a going concern. And again, resolution cost will be borne by the promoter. IRP conducted the voting of home buyers as to whether they agree that promoter to carry out the complete project, and almost 100% approval was there. Similar was being held in Anand Murthy Sons versus Sony Infratech Limited, where affidavit was given by the promoter that there will be timely completion of the flats and cost of the flats will not be escalated. What may be the effect of transferring it to the new resolution applicant? He might have increased the cost of flats, but it was being there that the cost of flat will not be escalated and IRP will submit the quarterly report to the NECLAT. So this was the basic one. But then a different view came in Nkumar R of Messer Sheltex Developers Private Limited versus Messrs Tata Capital Housing Financing Limited. There was a difference in the earlier cases and this case. CIRP of Sheltex Developer was initiated by NCLT Chennai via an order dated December 10, 2019. And Mr. Nkumar was appointed later as IRP and later he was confirmed as resolution professional. Sheltex was having two real estate projects, one at Appur Village, Chennai, and other at Namavedu at Coimbatore. Each project of Sheltex have different type of creditors which are not related to each other. Now, resolution professional relied on the judgment of Flat Buyers Association in Umang Tech Realtech Private Limited, which allowed the project-based insolvency. So what is he constitute project-wise COC? Because the creditors are different of each project, so he constituted a project-wise COC for conducting reverse CIRP and issue separate EOI for each project and invite the resolution project-wise resolution plan. NCLT dismissed this application. He said RP cannot go ahead on its own for the same. It is the home buyers and promoters who want to come and agree for the same. RP can on its own not decide for the project-wise insolvency. That was the particular thing. That's why this was being rejected. Project-wise EOI was rejected in this case. So this was the change that and now we know nowadays there discussions are going on, deliberations are going on for project-wise CIRP of the real estate sector, and sooner it is going to be permitted. If there is in between any query, if you are here and you want to put any query, then you please raise your query either in the chat box or you can unmute and ask at the same moment. Okay. There is a case of IBC and Arbitration Act. Section 9 proceedings are the proceedings where applications are made by an operational creditor under the code. IBC is not a recovery mechanism. Therefore, if there is a pre-existing dispute in relation to an operational debt, an application to initiate CIRP is not admitted. We know that the mechanism for recovery is different in case of operational creditor versus the financial creditors. Operational creditor first has to raise a demand notice under section 8, demand notice asking for repayment of the demand amount demanded or submitting the proof of a pre-existing dispute. This pre-existing word is qualified. It means before the demand notice is sent, there should be evidence that yes, some dispute or some arbitration proceedings were going on. An application filed by an OC under Section 9 during the pendency of arbitration proceedings. If arbitration proceedings are pending with respect to operational debt, then after the application under Section 9 is filed, it shall be rejected. The Honorable Apex Court in K. Kishan versus Vijay Nirman Company Limited held that a challenge to the arbitration award, if we know in the Arbitration and Conciliation Act, the award is being given, it can be challenged. And if there is a challenge, it means dispute is pending as far as IBC is concerned. CIRP cannot be initiated even if the arbitration proceedings are pending unless the challenge to the award has been concluded and the time period for filing such challenge is over and the award become final. So unless and until time period for filing the appeal is over, we cannot say that the award is final. So, however, due to the overriding effect of IBC, an arbitration clause by itself will not automatically outside the jurisdiction of NCLT if other conditions are permitted. So, if we say that this is the case where Arbitration Act requires that if any arbitration clause is there in any particular contract which comes for the arbitration, which comes to the courts, then they court on its own shall send it back to the for the arbitration if the defense is raised in the before filing the statement of defense by the defendant that this matter is to be decided by arbitration, then court will not interfere and will send it to the arbitration. The same thing is not applicable in case of IBC, though the agreement may have provision for the arbitration clause, but unless and until there is an arbitration proceedings going on or the arbitration award is there, but the time limit, either it is challenged or the time for challenge is not over, the application is not going to be admitted under Section 9 of IBC. So there is no defense of pre-existing dispute available under Section 7, but the same is available under Section 9. So Section 7 of IBC, there is no bar to initiate CIRP even if arbitration proceeding is pending. Such a bar exists only in case of Section 9. And how could it be raised if a matter is referred to a court that I said you then, but the other party has, what is important here is the defense of existence of arbitration clause in the agreement has to be raised in the first statement of defense by the defendant. If it is raised, then court will send it to for the arbitration. Otherwise, if no plea is taken, then court on its own will not send for the adjudication. However, the same do not apply to the IBC because IBC override Arbitration Act. That was what being held in the judgments. This was regarding the Arbitration Act. Is there anything which is requires the sales of goods act to come into pick? Is there anything which requires sales of goods act to come into pick for the purpose of IBC? It is required in case of IBC. What are the provisions of IBC? We shall look in this regard for Section 9 of IBC, which requires us to have knowledge of sales of goods act for the same purpose that is being here. And when I look for the part 2 definitions, first thing that is required is whether there is a dispute or not. Dispute means it can be either a suit or it can be arbitration proceedings. And it relates to the existence of the debt or the quality of goods or service, or there is a breach of representation or warranty. So if there are three things which are disputed, suit may be filed with respect to that, arbitration proceedings may be going on. These three things, these three defects are counted as dispute. And they do exist in the contract of sales. The conditions are being mentioned in the contract of sales. When I talk about the operational creditor in IBC, it means a person to whom an operational debt is owed and includes to whom such debt has been legally assigned or transferred. Operational debt means a claim in respect of the provision of goods, restricting myself here. So a claim in respect of provision of goods, it means the person classified as operational creditor if has supplied goods or services and he is having a right of payment with respect to that. We call that claim as an operational debt. When I talk about the section 9, again repeating, demand notice must be served. So first of all, there is a default of 1 crore or more. Demand notice is being served for 10 days. If not met or pre-existing dispute is not there, then section 9 application is there, which can be admitted or rejected. So an operational creditor, whenever a default is required to serve a demand notice, either in form 3 or form 4, and demand notice means a notice served by the operational creditor demanding the payment in respect of that operational debt for which the default has occurred. Then demand notice has to be sent to whom? That is there. 10 days notice. Here what is to be required? That within a period of 10 days of the receipt of demand notice or copy of the invoice, existence of the dispute, whether through the email it may be there, or exchange of letters may be there, or record of the pendency of the suit. Yes, suit or arbitrations are proceedings are pending. They shall be brought to the notice of the operational creditors. Whenever a CIRP is being there, the documents, if we'll say, if he is not receiving the payment or proof of pre-existing debt, he may file an application before the adjudicating authority. But what are the documents required to be submitted as demand notice? Documents served, relevant documents confirming yes, the OC payment has not been made, affidavit in support of the application, and written communication if IRP is being proposed. What has to be proved here is an affidavit has to be given that there is no notice given by the corporate debtor relating to the dispute of the unpaid operational debt. These two things are compulsory, that neither the payment has been made nor the notice of dispute is being given by the corporate debtor. What is the criteria for adjudicating authority while accepting or rejecting the application in this case? If the application is complete, no payment of the unpaid operational debt, invoice has been delivered, and no notice of dispute is received, neither by the operational creditor nor it is in the information utility, only then the application will be admitted. So this dispute is very relevant for the purpose of operational creditor. Even in the Mobilex Innovation Limited case, it was being held by the Supreme Court. While examining the application under Section 9, default is there. It is crossing the threshold limit. Documentary evidence is there that is due and not paid. And what it will see, whether there are dispute between the parties. If there are dispute between the parties and there is notice of dispute being given, then application under Section 9 will not be admitted. And what they are talking about, the notice of dispute, it shall be a dispute which must predate the receipt of the demand notice. And what can be the dispute with respect to the amount of the debt, whether the debt is existing or not, quality of goods or service, breach of representation or warranty, either directly or indirectly. Now, for determining the pre-existence of the dispute, we need to understand the provisions of Sales of Goods Act also, because that are giving a provision for the Sales of Goods Act. And it's Rajratnan Babulal Agarwal versus Solartex India Private Limited, where the provisions of Sales of Goods Act were discussed at length. First was that sales of goods, that it may be a contract where actually the property in the goods is being transferred or it is agreed to be transferred for a price. And whenever there are contract of sales of goods, that there are stipulations being exchanged with reference to the goods. And these stipulations may be condition or a warranty. A condition is essential for the main purpose of the contract, breaching of which may give rise to treat the contract as repudiated, but warranty is collateral. It give only a right to claim for damages and not to reject the goods. And a stipulation may be a condition, though by whatever name, it may be called a warranty also. So effect of condition, breach of condition is more than breach of warranty. But the thing is, can breach of condition be treated as breach of warranty? Yes, breach of condition can be treated as breach of warranty by the buyer. That may be there. He is not rejecting repudiating the goods contract. He is keeping them. But will he be entitled for damages as are available in the breach of warranty? Yes, it will be available to him. Now, there are circumstances in which breach of condition shall be treated as breach of warranty. The condition is contract is not swearable and the buyer has accepted the goods or in part. For example, he has consumed it and part of it. Then on that ground, breach of condition shall be compulsory treated as breach of warranty. And the entire sales of goods act is subject to the contract between the buyer and seller. Then there are implied conditions as to undertaking and other implied conditions also we are not discussing in length. The one we are discussing is when the property in the goods are being transferred unless and until something else is required. See, first there are the unascertained goods. We are just describing the goods. Then we identify, okay, particular this brand is required. We will ascertain, and from that, whatever is specifically sorted out for the buyer and taking his consent, it is appropriated goods and they are to be put in a deliverable state. And when they are put in a deliverable state and both the seller and buyer are aware of it, at this stage, the goods and property in goods is being transferred. And if further is left out for weighing or something on the part of seller, unless and until that is done, property in the goods will not pass. Buyer has a right to examine the goods if he has not previously examined. Unless and until that opportunity is being given, he is not deemed to have accepted. Whenever the seller tends to delivery of the goods, he is liable to give buyer an opportunity, reasonable opportunity of examining the goods, whether they are in conformity with the contract or not. And buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them, or when the goods have been delivered to him and he does something which is inconsistent with the ownership of the seller, or after a lapse of reasonable time, he is retaining the goods and not intimating it. This is the stage where the acceptance is counted and where our case is going on. And the one who is being the operational creditor means he is an unpaid seller who will file an application under section 9 of IBC. Right. What else is important here now is the judgment that we have to discuss with respect to the sales of goods act. Here there were Rajratan Babulal Agarwal, who was an ex-director of the CD against which this CIRP was going on. The three respondents were there. First was the operational creditor, second was the Solidaritex Private Limited, and third was the IRP. NCLT admitted the application filed by the OC under section 9. IRP was appointed as an IRP. NECLAT has dismissed the appeal filed challenging the order, and then that's why the appeal is filed before the Supreme Court. NECLAT has stopped this. The question which falls for the consideration is whether the appellant has raised a dispute which can be described as a pre-existing dispute. Whether CD has some dispute which can be categorized as pre-existing dispute. So there were 3 maize that were being exchanged for the delivery of the coal. Majority of the coal was being delivered, and the 3 maize highlighting that yes, the coal was of poor quality. So no further delivery is to be made. Stop the delivery. So it was being confirmed. Yes, the delivery has been stopped by the operational creditors. Further supply was stopped and a notice was being given that give us the amount with a 30% rate of interest. corporate debtor, and after the exchange of notice, an application was being filed, and after the filing of the application under section 9, the case was being filed in the two civil suits were filed in the court. Because the civil suits were filed after receipt of demand notice under section 8, that's why they were not assumed to be the pre-existing dispute. It was the case that was considered by the NCLT. But what the neglect said, okay, with respect to those civil suits, there was no pre-existing dispute. But if you go through the emails, they were saying, yes, there was a dispute as far as quality of goods was there from the side of corporate debtor. So as the mails are indicating, yes, the goods were not in conformity with the terms of purchase order. Next thing was they were consumed by the corporate debtor, they were not returned back. It's referring to the Sales of Goods Act. It was said that mere intimation by the buyer is sufficient. He is not bound to give the delivery back to the seller. The intimation was there, and a buyer has a choice to treat the breach of condition as breach of warranty. So if he has kept the goods on the presumption that he will go ahead for breach of warranty and claim damages, it is again an existence, that is a dispute is going on. So consumption of gold is not a ground for saying that the buyer has accepted and it is a contract of sale. So it said that buyer has treated the contravention of condition as a violation of a warranty, and therefore he has a right which are declared in section 59 of the Sales of Goods Act. What are the remedies which are available in case there is a breach of warranty, whether it is elected or compelled? He can sue the seller because of breach of warranty, whatever the damages suffered, as well as the diminution of the price because of giving the lower quality or breach of warranty. He can further go ahead for the damages also. So in this case, section 59 was upheld, and it was being said because the buyer has treated breach of condition as breach of warranty, he can go ahead for the diminution, breach of warranty against the seller for extension of the price or decrease in the price, and sue the seller for damages for breach of warranty. So the act of consumption is not constituting it. And in section 19, what is to be seen, there is an operational debt. The documentary evidence are some supplement given which are showing, yes, debt is due and payable and has not been paid, and there is existence of dispute between the parties by way of a suit or proceedings or from the record. If any of the condition is lacking, then the application will not be admitted. A perusal of the email would clearly indicate that though it was sent by the sister concern of the second respondent, but it is with respect to the corporate debtor also, raising the issue of the quality of gold, that is being the subject matter of the contract of sale. So there was a contract of sale for the goods, and section 59 will come into a track which will give a breach of warranty as a plea for the same. The factum of filing the suit will not be taken into consideration because they are filed after section 8 demand notice is being received. Though there was no debit note in the supply in respect of the supplied goods, accounts are not in the CD, there is no accounting for the losses. No account has been passed, but mails are evidence of a pre-existing dispute. And if there is a pre-existing dispute, then the application filed by the first respondent against the second under section 9 will stand rejected. So the appeal is being succeeded, and section 9 application was being quashed here on the ground, seeing the provision of the Sales of Goods Act, where the buyer has being the CD has treated breach of condition as breach of warranty. So the other plea is that he has not rejected the goods, he has not sent back anything else, no account entry is there, nothing was allowed, and the plea application CIRP under section 9 was quashed. So this was what was the Sales of Goods Act. Anything else if you want to know, you are most welcome. Or if there is no other query, Anjali, I think we can end the session also.
Ma'am, I have one query regarding this CIRP initiation under Section 9. One of the operational creditor has initiated a CIRP, but the project name mentioned in the order is not correct. So I have been appointed through NCLT only. So what steps we can take? I mean, we have filed a memo to the NCLT that the project name mention is not correct. But we cannot start the CIRP process as such, na? What are your views?
If the documentary evidence is there, whenever you have filed an application, you have stated the right name. The correct name is there.
Yeah, correct name is there.
So you are thorough with it. Okay. This is only a clerical mistake. That can be a clerical mistake also.
Clerical mistake is there, but the CD is not ready, na? Because the project name mentioned in the order is not correct.
I do understand for that. You have filed the application.
I have been appointed through NCLT only.
You have been appointed through NCLT. In that case, then you have to start it. We can file it as on this, but my clock watch has started running because all the things which are in support of that application, they are saying what was the project. Why that may be a clerical error. Corrections are
Yeah, clerical error is same. Clerical error is only there.
so that we have started it, but we can simultaneously start section CIRP also.
No, madam, but in the public announcement and all, we have to mention the this one project name. But in the order, it is different.
You have to mention the project name. As far as I think this, with the precaution, we can mention that the name is wrongly mentioned here, though it was stated in the Section 9 application. That precaution we can take here. Because if we are waiting till the NCLT is giving a clarification, I think time will run out.
Yeah, that is what because I mean when we got the order immediately, we have gone to NCLT and we have mentioned the matter. Then on the instructions of NCLT only, we have filed a memo.
Then I think we can wait.
That is what.
I think we can wait and we can always take a plea because the project name was not clear in the order itself. So that could be a sufficient plea for us. But then
Okay.
again, it depends upon how it is being argued in the.
Correct.
I think NCLT will not take feedback because it's own mistake at their part.
Yeah, that is what.
It's not mistake at the CD part or being a IRP. It's not my mistake.
Yes.
So being legally, you equip yourself with everything that we were ready. But the thing was this, you couldn't. Yes, it's the NCLT mistake. I think we can wait for it also.
Okay.
But again, I am saying so many judgments, earlier judgments are getting reversed later on some other plea. In that, whatever is the best precaution available to us, we shall take it. We shall legally make continue us to make strong.
Yeah, that is what we are trying our level best because we are, I mean, all the regulatory authorities, we have already mailed along with the documents that so and so thing has happened. So we are not starting the CIRP process.
And right, it's
we are
okay.
waiting for that.
It's okay. If there is no time lag in it, it's a right course of action.
Okay, ma'am. Yeah.
Right.
Thank you, ma'am.
Thank you. Thank you, everyone. Thank you. If there's any other query, you can put in here. It can be of help to others also. Like Charu he was there, so it can be of help. Whatever one is facing the issue, other may also face at some or other level. Right? So thank you, everyone. And thank you. I think we can end the session right now. Thank you. Thank you, everyone.
Thank you very much, ma'am. The session was very informative and interactive. And thank you very much for sharing your valuable thoughts and experiences. Ma'am, you are requested to please share your PPT with us.
Yes, sure. I will share the PPT. I will just mail you. Okay. Thank you.
Thank you, madam. Thank you very much.
Thank you. Thank you, British.